Hello, everyone. This is Sydney from TechServe Alliance. Welcome to today's webinar, Avoiding the Pitfalls, Common Compliance Mistakes IT Staffing Companies Often Make. There will be a question and answer session following the presentation, so please write any questions you want answered in the Q&A box, which can be found at the bottom of the screen. We are also recording today's presentation, which will be available on the TechServe website and will be sent out in follow-up emails. Now, I'd like to introduce you to Marty Borosco, Partner and Staffing Practice Leader at Becker LLC.
Thank you, Sydney. Appreciate TechServe having us on today. Good afternoon to everyone on the East Coast, and of course, good morning to everyone joining us from across the rest of the country. A really practical and important webinar today. I mean, we have a lot of webinars that are, forward-thinking, can be very based on philosophy or various different things, but this really today is a very practical and important webinar, and it's simply on common compliance mistakes that we see in the IT staffing industry. I'm lucky to have two industry veterans joining me to discuss this topic. We have Jerry Grady, the Staffing Industry Practice Group Leader at UHY. Welcome, Jerry.
Thanks, Marty. Glad to be here. I appreciate you guys having me on.
It's always a pleasure to speak with you. We also have my partner, Chris Leddy from Becker. Chris is former in-house counsel at an IT staffing firm, and now he's one of my partners in the staffing practice group at Becker. Good afternoon, Chris.
Good afternoon, Marty. Thank you, TechServe, for having us.
So let me set kind of just a little bit of background here. I mean, it seems, for the last 15 years, what this industry has been really facing is what I would call a never-ending quest to stay compliant with a always changing landscape of federal, state, and local laws that affect the industry. I mean, gone is the time 20 or 30 years ago, Chris, you won't remember, but Jerry and I will, where we had a strong federal government and most of the regulation that impacted our industry came from that strong federal government. The past 20 years, we've had an ever weakening federal government, and with a weak federal government and with greatly divergent political beliefs across the country, states and local governments have taken that as an opportunity to really step in and become almost unabashed in and about passing regulation that impacts our industry. And obviously it's made the regulatory environment more and more complex and increasingly difficult to keep up with. And so, we have folks who misstep from time to time. Today we're going to talk about what we see as the most common mistakes. I think between Jerry, Chris, and I, we have 50, 60 years of experience in the industry. We've probably served close to 250 clients, and we just sat down before this webinar and we just picked out the mistakes we see most often. So can't cover everything today, but that's what we're going to cover, the mistakes we see most often. And Chris, why don't I jump in with you? This is one you and I see all the time. You see it maybe on a compliance end. I see it in mergers and acquisition diligence, and that is how difficult it is to comply with the federal background check law, the FCRA, and also state and local background check laws. So Chris, let's start with the FCRA. Maybe explain, most common mistakes that you see with respect to IT staffing firms and their compliance with the FCRA.
Yep. Thanks, Marty. So as we know, a lot of staffing companies' clients, especially in the IT industry, require that a candidate successfully complete a background check in order to get placed there. That typically involves a criminal history report and sometimes a financial report. What the client contract does is it disqualifies candidates if they have been convicted of a crime of moral turpitude, such as fraud or embezzlement. So staffing companies regularly do conduct these background checks to ensure that the candidate is eligible for the position, A, and B, that they're not going to that the staffing company is not going to violate the contract or breach the contract with the client. In accordance with the Fair Credit Reporting Act, in order to conduct a background check, you have to provide the candidate with an FCRA disclosure, secure a written authorization from them, and if the company is going to share the report with the client or any other third party, you have to get consent from that candidate. All right. So while most staffing companies generally do comply with those three requirements, some fail to comply with the nuances of the FCRA, which we have seen lead to class action suits to the tune of millions of dollars. The suits typically involve the disclosure and authorization portions, as they have to be in a standalone format, right? Meaning that the authorization and disclosure, they can be one document, but nothing else can be in there. No other ancillary language, no other disclosures, no other information, including that information required by state or local law. In fact, in a recent Ninth Court decision entitled Walker versus Fred Meyer, Inc., the court held that beyond a plain statement disclosing that a consumer report may be obtained for employment purposes, the disclosure may also include some concise explanation of what that phrase means, such as briefly describing what a consumer report is, how it will be obtained, and the type of employment purpose for which it may be used. The court then further held that additional information regarding the applicant's rights under state and federal law, even if it's included in good faith, was extraneous and was not permitted to be included. So what does this all mean? Basically, according to the Federal Trade Commission, you have to provide a clear and conspicuous written disclosure that you plan on getting a background check about them, and you must get their written authorization. It's okay for you to combine those, but they have to be clear and in a format that they will understand. Disclosure cannot contain indemnifications, other consents, acknowledgements that the information is correct. Those can be provided, but they have to be provided in a separate document altogether.
Let's stop there, Chris, because I see this in diligence for M&A activity where one of the parties, the buyer, is looking at the compliance practices and any compliance concerns with a seller. And what I commonly see, and let's see if this is what you see with the FCRA, is that our clients, because they have to comply with the FCRA and then they have to comply with similar laws in other states where they're placing people, we'll put a disclosure together that at the top will be the FCRA disclosure, then they'll have Ohio's disclosure, then they'll have California's disclosure, then they'll have New York's disclosure all on one page. And as you just said, right, that's not permitted, correct?
Not permitted yet. They should all be separate documents that you're having them sign, which obviously is tedious, but the law is what the law is, right? And there have been findings that those are violations and there have been damages awarded.
So I think it's actually rare. Would you agree with this? That when we do diligence that we find somebody that's, I'm not gonna say rare, it's common when we're doing diligence that we find folks that do not separate those. Is that fair to say, Chris?
Correct, I would agree, unfortunately.
So let's go on to the second aspect of FCRA that I think brings up a lot of compliance issues. And that's the process that you need to follow before you take adverse employment action based on the results of a background check. Can you talk about that a little bit?
Yep. So before you take an adverse employment action or against an applicant or an employee, a pre-adverse action letter has to be sent, or notice has to be sent. The notice has to include a copy of the consumer report that you're relying on to make your decision and a copy of the summary of rights under the Fair Credit Reporting Act. So that's two pieces of information you have to provide at the pre-adverse level. By doing this, you're giving them notice in advance to challenge the information, right? And tell you what is correct and what is not correct. Obviously, that's up to you how you interpret it. Generally, you have to wait at least 5 days before you then take the next step, which is the ultimate adverse action, which is either rejecting their application or terminating their employment or taking any other employment-related action, whether it be reassigning them or denying them a promotion. If you do take an adverse action based on the consumer report, you have to give the applicant or employee notice of that fact. It tells them about their rights to see information being reported about them and to correct that inaccurate information. The notice has to include the name, address, phone number of the consumer reporting agency, that supplied the report, a statement that the company that supplied the report did not make the decision to take this unfavorable action and cannot give the reasons for it, and a notice that that person has a right to dispute the accuracy or completeness of the information and to get an additional free report from the company if the person asks for it within 60 days. So again, you can't just deny somebody. There are steps you have to take. Otherwise, you risk violating the FCRA, subjecting you to damages.
Thanks, Chris. I know there's so many state laws that mirror or are more restrictive than the FCRA. Obviously, we can't get into all of those. I do want to talk about two because I think there's been a lot of issues with respect to both of these. The first one is the New York City Fair Chance Act. Maybe you can talk to folks and explain what that entails and some of the difficulties of compliance with that act.
Sure. So the Fair Chance Act, it was amended on January 10th of this year, and that amendment went into effect on July 29th. Under the act, employers can only request and review criminal history information after evaluating all other non-criminal information. This means that employers can only perform criminal background checks once a conditional offer of employment has been made, and it's the absolute last step of the process, right? You cannot circumvent the regulations by calling an offer conditional before you have assessed all other employment qualifications, aside from criminal history and perhaps medical information. For example, you would have already had to assess their academic records and their references prior to doing so. Also, if you change the duties and responsibilities under the job description after the criminal history report, it's a pretextual basis for a discrimination lawsuit. So there's no way you get out on a motion to dismiss. The court is going to make you move forward with that. So make sure your job description remains consistent. And I think New York City, for better or worse, is more on the trending side when it comes to laws, especially employee-friendly laws. So it's something to keep in mind, not just in New York City, but across the country.
And similarly, I feel as though Illinois is really taking the lead and it's been passing a lot of regulation with respect to background checks. Can you talk about some of the latest enactments in Illinois and how they affect the industry?
Sure. So I agree with you. Illinois' law is something to definitely keep an eye on because unfortunately, it could be a precursor of what could come at even the federal level. So what the Human Rights Act there did, or previously did, was it prohibited employers from making adverse employment decisions based on an arrest record. However, it's now been amended to prohibit employers from making adverse employment decisions based on conviction records, except in two circumstances, right? In order to legally consider an employee or an applicant's conviction record under the amendment, one of the following two conditions have to be met. There must be a substantial relationship between one or more of the previous criminal offenses and the employment sought or held, or the granting or continuation of employment must involve an unreasonable risk to the property or to the safety or welfare of specific individuals or the general public. So you then have to look at, well, what is this substantial relationship? According to the law and the answers to the FAQs, it's whether the employment position offers the opportunity for the same or similar offense to occur and whether the circumstances leading to the conduct for which the person was convicted will recur in the employment position, right? But it doesn't stop there, right? You have to look at 6 factors. The factors are the length of time since the conviction, number of convictions, the nature and severity of the conviction, and the relationship to the safety and security of others, the facts surrounding the circumstances of the conviction, the age of the individual at the time of the conviction, and any evidence of rehabilitation efforts. If after you consider all those mitigating factors, you want to take an adverse action, you're going to follow similar steps, even though it's not identical to that of the Fair Credit Reporting Act.
Thanks, Chris. Well, if it's not employment compliance, it's state and local tax issues, Jerry. That's like the competition for the 2 areas where, folks in the IT staffing industry are most likely to have issues. Let's jump into a few SALT issues. I know one is source of revenue. I imagine. Do you want to talk a little bit about some of the common mistakes that folks make in that area?
Yep, it's obviously not as exciting as Chris's, background checks and unemployment and not being able to hire someone. Very interesting stuff that Chris, you just provided, because there was something there I had not known about. So that's great to hear. Sales factor apportionment is probably the biggest thing that we see right now in all IT staffing firms. The work from home model has definitely created a lot of issues for not only IT staffing firms, but engineering staffing firms as well, and a host of other staffing firms. What a lot of states are doing is they're trying to get a hold of your tax dollars. They want to make sure that they get their fair share of every dollar they can possibly get. And so it's important for you to understand what is called nexus, which really is a phrase that's used to determine whether you have done business in that state and therefore owe tax, or haven't done business in that state. Well, many states have gone about and created their own new factors for apportionment by getting rid of nexus in their state. There used to be there still is a rule, PL 86272, if I'm quoting it correctly, that was defined on how you pick up income in each state. Well, a lot of states have put these workarounds in, and they've gone to a cost of performance state or a market state. And they really do affect where you're doing the work. So if we look at cost of performance, what you're looking at is where is the sourcing of the receipts? Where are the costs being taken into consideration? So, if I pick on the state I'm in Michigan, we are a 100% cost of performance state, basically saying that, our costs are done here in the state of Michigan and our receipts are done here. So if I'm working on an IT staffing firm that does business in, I got to pick a state we don't have an office in, let's say North Dakota. North Dakota would definitely be, a non-taxable state for us if I'm working on that client, but I'm doing all the work here because all my receipts are being sourced to Michigan. All my income is producing property is in Michigan, meaning the employee, and all my other costs such as tax processing and admin and rent and so forth are in Michigan. So that's what a cost of performance state would be. What we're seeing a lot more of is many states going to what they call a market-based state. And a market-based state is where you are looking at where is the sourcing of the receipts from a standpoint of where is the benefit received, where is the service received, where is the service delivered if you're an engineering firm, and then where is the customer located. So if I take the fact that I take my employee in Michigan and now I'm doing work in Illinois, but I'm doing all the work out of Michigan, I have an issue because Illinois is a market state. And so therefore, I have to file potentially a tax return in the state of Illinois because I am having the benefit received there. I am providing the service there, and I'm delivering the tax returns to that individual. So what that does and why it's really important to know about whether you're a cost of performance or a market state on where your work's going, because you potentially could have double taxation. You could literally be paying the same tax on the same income in both states. Now, there is a tax credit obviously available for your home state, but again, the dollar I generated in Michigan is the same dollar that I'm going to have to pay tax on in the state of Illinois. So that creates a problem. In addition, a lot of states have what is called throwback sales, meaning that if you have sales in some of those other states and you are a C corporation, it allows for a really nice apportionment on a C corp. But if you're an S corp or a partnership, The throwback rules basically say we're going to pull all that revenue back in to this state. So if I take a staffing firm in Michigan who did that work in Illinois, all of a sudden, the individual filing their tax return in the state of Michigan is able to exclude that revenue from their personal return because the revenue was put in Illinois. However, they do have to file an Illinois return. So there is a lot of advantages from a tax standpoint to understand these rules. Chris, or I'm sorry, you know, at the end of the day, Marty, you know, we look at the risk versus the reward. The idea is let's take a look at what you're doing in each state, where some of those cost of performance issues could be, and then look at what is the risk that you're looking at. Because obviously you don't want to start filing, you know, 50 state returns because you did, you know, a couple $100,000 in a market state. Now, market states have also put in revenue numbers. So each state will have their own revenue number. And therefore, if you go into, say, Michigan, $350,000 is a number. If you go into Washington, it used to be 100. They're looking at raising it. But again, a lot of states are driving revenue from the tax side. So they're looking to lower some of these thresholds instead of increasing those thresholds.
Yeah, that's a really complex issue. Interesting question for you, because I've had clients come to me under the, especially folks in more of the permanent placement, IT permanent placement than contingent. And for some reason, they think because they're in permanent placement, the sourcing tests are different for them. Is that the case?
Nope, it is, you know, the idea is if it's a market state, it's, you know, where the benefits received. So if you're, you know, if you're a permanent staffing firm in California, but you're putting somebody in Washington, for example, and that it's a high level management position in Washington, and let's just say you get a $40,000 or $50,000 fee, technically that receipt is a market receipt in the state of Washington. So you do have to keep track of those receipts coming from those various states. It can become very cumbersome. So what you would want to do is, again, look at your risk, make sure you know what the total revenue is for each market state. And then as you get closer and closer, then you start really analyzing what you need to do.
That makes sense. Another issue that I think a lot of folks find confusing is sales tax, right? They're staffing firms, they're providing a service, and the assumption is in a lot of cases that maybe sales tax doesn't apply. Can you talk a little bit about sales tax?
Yep. There are approximately 9 to 10 states now that are collecting sales tax. For all of you on the call, you probably are well aware Ohio just terminated their sales tax on staffing. So that's been a huge, huge help to a lot of Ohio firms. The 9 states that are collecting sales tax, what you do need to look at is you do need to go down to, again, the market versus the sourcing. So is it a performance state or is it a market state? And so if I take Pennsylvania, for example, Pennsylvania uses a market work, meaning that if I'm providing the service on a call center, which is what a lot of IT staffing firms are doing, and that service is for a customer who is based in Pennsylvania, technically you are supposed to be collecting sales tax. You know, there was just some updates on that about 2-3 weeks ago, and Pennsylvania was reinforcing that heavily in some e-alerts that they were sending out to people, because they know that these IT help desk, and you know, they're all work from home now. The people are working in other states instead of going to the support center that was in Pennsylvania. So Pennsylvania is a state that you definitely want to take a look at what you're doing in that state. Remember, sales tax, Marty, is also a tax that's not your issue, it's the customer's issue, but it's your issue when you fail to collect it, because the odds of you getting it from your customer are, you know, as you know, pretty slim to none. And you'll be the one fighting the sales tax audit, not your customer.
Right. That makes sense. So that's an important point. Anything else you want to talk about on SALT before we shift issues?
I think also the other area that a lot of IT staffing firms miss is what's the responsibility for them on withholding on employees. That employees withholding is done where they are providing the work, because that is what you as the employer are responsible for. So if they are doing the work in, say, Ohio, then they are going to be withholding the Ohio tax. Or if they are in, New Jersey, they are going to be withholding the New Jersey tax. However, if you are sending them to various states and they start spending usually more than 14 days, you really want to take a look at it and see, should I do some withholding there, because they may have tax due in that state. Remember, an employee is always going to file a return in their home state. You as an employer are required to withhold in the state that the work is being performed, and you can voluntarily withhold in the state that they reside in. And that holds true also for local taxes. Local taxes are probably more difficult than the state taxes, because in a local tax, you could live in a city that doesn't have tax, but work in a city that has tax, i.e. New York City, i.e. living in New Jersey on the other side down in, in shore territory. So those are some of the issues that you have to look at, because if you're not working in that city, you're not paying tax anymore. And again, because these cities know that, they've lost a lot of revenue. And so they are going to start looking at and figuring out who was in our city before, isn't here now, and didn't file a return. So it's very important that you stay focused on that issue.
Thanks, Jerry. Before we switch off the tax issues, one issue I see often in legal due diligence, I've seen in a number of cases, is when IT staffing firms are offshoring in some form, especially in India most commonly, but other areas, often they think they have no tax filing requirements for that foreign subsidiary, and they don't. What's that?
5471 and 5472.
Yes, and they don't file those forms, which, as I recall, I think it's $10,000 a year automatic fine if you don't file that form. So anybody who has any foreign subsidiaries, make sure that you're filing your those forms, because I've seen it at least 5 times in IT staffing firm M&A deals where the seller has had a foreign subsidiary and had a history, a long history of not filing those forms.
Yep, and it works both ways. It's both on the inbound and on the outbound as well. So, be very cautious if you are, a subsidiary of a foreign owner, or you are a U.S. corp with a subsidiary in those areas. And that's just one of the issues, Marty. The other issue you have is many of our, owners of IT staffing firms have signature authority on a lot of those bank accounts in some of those other countries. That is even a bigger issue, because that does require a filing of Form 1114, and that is another $10,000 if that form is not filed, timely with your tax return. So that's extremely important to look at as well.
That's a great point. Let's shift, well, not really shifting away from taxes, but let's shift a little bit to the ERTC and the infrastructure bill. We're quite a bit into the availability of that credit. I know, Jerry, you've been helping so many folks in the industry maximize that opportunity. Maybe you could talk for a few minutes about the mistakes that you're seeing people make with respect to filing or not filing for the ERTC.
Yep, I think the biggest mistake that we've seen is that there is an area, what we're calling the PTO area, where people are using, their paid time off time as part of that calculation. And the actual, FAQs and regulations state that you cannot use sick pay or PTO pay in that calculation. So that is one of the areas that we've seen a couple of our staffing firms take a pretty aggressive approach on that they really don't want to do that. The other area that we've seen some really aggressiveness on is what we were calling on the partial shutdown and the definition of it.
Yes.
As in everything, there's always you're looking for the language. And unfortunately, right now, there is no language or new guidance on what does dictate partial shutdown. And so I really have been cautioning a lot of people is to really think about what the intent of the law was, so that when you're looking at and saying, well, did my recruiter who couldn't really take on, and go to the office to make phone calls, is that a partial shutdown because they can't make phone calls? Well, one attorney we spoke to said they can make phone calls from their house. So how is that a partial shutdown? Because they can still generate the revenue and still generate what they were doing. So I think it's important on that, on the ERTC, that you really look at it. What I'm really worried about is the IRS all of a sudden starts seeing how much was paid out in ERTC, come September 30th. And they start seeing $1 million, $2 million, $3 million being pushed to all these staffing firms. And then all of a sudden the industry is seriously attacked. My tax leader here, who runs our entire tax practice, national group lead, he looks at it and says, this is like the Wild West of the roulette gun draw. If you go back to when R&D tax credit came out, everybody took it without knowing what it meant. And 3 years later, everybody was under audit. So, that's my fear right now, Marty, is I'm really worried that, I'm going to make a lot more money helping people on the audits than I am actually calculating the ERTC.
I am right with you. We've been asked probably, I don't know, a dozen times to offer opinions about the partial shutdown rule from clients who were getting advice from other folks indicating that they believe they qualified under the partial shutdown rule. And Chris and I have said, yeah, no way. There is no way we are giving you an opinion that this qualifies as a partial shutdown. So first of all, there's not much guidance out there,
right? That's the issue.
What that is. So that's a big problem. And second of all, I agree. It's the same conversation I've had. What is this? What is the intent of this? And partial shutdown. A lot of folks are meaning if one immaterial aspect of our business is altered as a partial shutdown, and it just, I don't believe was meant to stretch that far. And I agree. I think we're going to see a lot of folks, if they start auditing this, having some difficulties proving that they were eligible for these credits. So we may be doing a webinar for TechServe in a year about how to handle the audit for these folks that got a little aggressive, and it's some of the professionals out there, I think, pushing folks to be aggressive, which I think is a little bit of a disservice, to be honest.
And I've always, Marty, I'm always cautious. Because like you and I, we'll have a disagreement on a certain area of the law, because you read a word one way, I read a word one way. That's legal opinion. The problem is we don't even have a word to read, as you said, to come up with an opinion. And so it's really hard to explain it. And I think what I can say is that I do believe the government figured it out, because they put in the new infrastructure bill that it ended on September 30th. There's obviously a reason they felt it needed to end on September 30th. Now, it still hasn't ended for everybody on the line. It's in the infrastructure bill. So if the bill does pass sometime, from now till December 31st, then the fourth quarter is off the table. But I'm telling I am still telling everybody that if you did qualify in that third quarter, because your revenue was down 25%, then you know what, that fourth quarter still should be a strong and is still an applicable quarter for you, for the ERTC. But again, I think they have some headwinds and they've made some decisions that they're going to try and stop the bleeding, because I think they've seen some of these checks going out.
Definitely. We've got a question, Jerry.
I saw that. Yep.
Yeah, do you want to answer that? Is there somewhere a source for folks?
There's really, part of the problem is we've always thought about creating a template for everybody. The problem is just like with the PPP, I'll put it out at 9 a.m. and by 9:35 it's wrong. And so we don't do that anymore. There are some websites out there that I do send people to, BNA being one of them. They're a really good website. Walter Clow is another good website to go to, Thomson Reuters. Every once in a while, you can find some information, but it really is a simple Google. If you're going into a state, literally just Google, is this state a market state or a performance state? And you'll at least get to some type of tax area that you can read. We do a lot of compliance for our clients, so they hire us, on a contingency basis, and they just send us an email, and then we just look it up and give it to them. Because there is, like I said, BNA has a really good tax checklist you could use, but it is not a cheap tax checklist, because they're updating it every day as well, because laws change all the time.
Chris, let's shift over to you again and talk a little bit more about some really important areas of employment law compliance. And obviously with COVID and vaccines and testing, obviously of all of those, can you test, when can you test, all of those issues that people have talked about so much, and for a lot of great reasons, because it's important in these times. But what I think some people don't realize is that there's some wage and hour implications to this. Could you explain how wage and hour works into this?
Yep. So federal regulations state that the time spent by employees waiting for and receiving medical attention on the premises or at the direction of their employer during their normal working hours constitutes hours worked, which means they have to be compensated for it. Courts have interpreted this to mean that that they had for mandatory testing, even if it's outside of the normal working hours, right? So if normal work is 9 to 5, if you're requiring them to get tested before they come to work, that would be at the direction of the employer and be compensable. The Department of Labor has affirmed that that is correct as well. Essentially, it is likely to be found that employees must be paid for the testing time if it is done as a requirement for the employer. This is consistent with many state laws that require employers to pay for all time spent while under their control or direction.
Just to make this clear, Chris, because I had a client ask me this question, that applies regardless of whether you're doing the testing at the place of job or you're sending them out to a private place to be tested, correct? Both, in either instance, that probably is compensable time. Is that correct?
I would agree. And if you're sending them somewhere, that mileage, that travel time is probably compensable as well. So that's something to keep in mind too. If you have your pluses and minuses about doing it on site or off site. Obviously less risk for you violating the ADA if you do it off site with somebody you don't have a contract with, but by you requiring them to go, you do have to pay wages.
And then the follow-up question I had from that client is the cost of the testing reimbursable?
So likely, yes. When employers fail to reimburse for expenses considered primarily for the benefit or the convenience of the employer, which these obviously are, the FLSA considers this to be an impermissible wage deduction to the extent it reduces the employee's protected wages, which are their minimum wage, as the employer testing mandates will be seen as primarily for the benefit of the employer to minimize workforce disruptions and comply with workplace safety requirements. The EOC has also chimed in on this. According to the EOC, when an employer requires an employee to go to a healthcare professional of the employee's choice, the employer must pay for all costs associated with the visit. This may occur where an employer requires testing, like you said, at a designated site or provides on-site testing. Additionally, you want to keep in mind too, this is federal law, right? State laws have their own laws that you have to comply with. So like California, there employers are required to reimburse the cost of the mandatory testing, including reimburse their mileage. So employers have to keep in mind what state they're in, where they're requiring the test. So it's not a one-size-fits-all approach here.
Yeah, I found that very interesting, and a lot of folks aren't focusing on those issues. Sticking with wage and hour, let's talk a little bit about the recent case law that came out of California. California, Illinois, New York, we keep talking about those states. It came out of California with respect to rest and meal periods. Can you update us on that?
Yep, so the new case that came out in California basically said that they had to be, so what the law says is they have to pay their hourly rate for the time that they weren't provided their meal and rest periods, right? So it wasn't entirely clear what their hourly rate was. Well, the court came back and said it's their premium rate, right? So it's, you have to, the way you would pay overtime in any other circumstance is how you're going to pay them for that missed meal break. Meaning you have to take all their compensation for the week and then work your way backwards, right? What would be their hourly rate? So if you have commissions built in, they missed it, that commission's paid in that week, you now have to factor the commissions into their hourly rate, and that would be their premium pay for that missed meal break. So it becomes a much tougher process if you have people missing meal breaks in certain states.
Yeah, that's pretty complex. That'll be something Jerry's helping folks with down the road.
Yep.
So this is the part, Chris, I hoped we wouldn't get to, because this is the part where everybody in the industry is going to hate you and I. Let's talk about classification of recruiters, because I know that every IT staffing firm believes all of their recruiters are exempt and an exempt status, but let's drill down on that a little bit. Are recruiters automatically entitled to exempt status, Chris?
So maybe. Right. I'm an attorney. That's what I get to say.
I just called my HR lady and told her, Chris, you said maybe. We're good now.
If you want, generally going to fall under the administrative exemption, right? And there's 3 requirements for the administrative exemption. That's going to be meeting the salary rate of $684 per week. The primary duty is office or non-manual work, directly related to the management of the company. So those 2 are normally no issue. We won't even talk about those. The third prong is whose primary duty includes the exercise of discretion and independent judgment with respect to matters of significance. And that's really where the case law comes down, and we'll find whether someone is exempt or non-exempt. So what that does is it implies that employee has authority to make an independent choice free from immediate direction or supervision. However, employees can exercise discretion and independent judgment even if their decisions are reviewed at a higher level. On the other hand, you have to think the exercise of discretion and independent judgment has to be more than just using a skill and applying a recipe, right, or a procedure that the company has put out. So how do we know if they're exempt or not? Federal regulations do state that human resource managers who formulate, interpret, and implement employment policies generally meet the duties test. So a lot of times recruiters are very similar to human resource managers, but a lot of times they're also similar to personnel clerks. So what they say about personnel clerks is those are people who screen applicants to obtain data regarding their minimum qualifications and fitness for employment, and they do not meet the exemption. So courts have to look at the specific facts of each case. I'll go over a few cases real quick where they found that they did meet the test, right? In one case, the plaintiff's job titles were successfully recruiter 1, recruiter 2, and account recruiting manager. The key aspect of those duties were she did not screen solely for minimum qualifications, but also sent candidates to her account managers whose personalities made them a good fit, even if their qualifications weren't up to par. She negotiated overall pay, holiday pay, vacation pay. She managed the contract employees while they were on assignment, assessed and investigated problems, counseled and disciplined the contractors. She was not subject to immediate direction or supervision, and she was in charge of generating business from particular clients. So even though the fact that she would consider a particular wage range when negotiating pay didn't mean she didn't exercise the necessary discretion, the court found. So she did meet the requirements and she was classified as exempt. Another case, the plaintiff was labeled as a staffing coordinator. Her duties included managing client relationships and counseling and disciplining staff who did not comply with client policies and procedures. She was also responsible for implementing important management policies and operating practices, and doing so in a manner that would ensure that the professionals placed with the clients were capable of producing acceptable services. There again, they found that she had met the administrative exemption. The wage and hour division was asked a very similar question. In analyzing the duties there, they pointed to the contrast between human resource managers and personnel clerks, which we just discussed, and concluded that staffing managers exercised the requisite discretion and independent judgment to qualify for the exemption because it was their job to recruit, interview, hire, and recommend placement of employees to particular assignments, manage the client's temporary labor pool, provide advice on personnel issues, handle complaints, resolve grievances, and terminate employees on behalf of the management. Well, there was one case that came out on the opposite side, and I think it really depends on how your company is structured. So this case may apply to some of you and may not apply to the rest of you, right? There, the recruiter's duties were to search for qualified individuals, determine whether the background matched, determine the salary requirements. The recruiter then would provide the resumes of the qualified candidates to the account manager, who would then decide whether to present those candidates to the client. If the account manager did so and the client was interested, the recruiter would then schedule an interview. If the client wanted to make an offer, the recruiter then participated in making the offer to the candidate. The court found there, basically the person acted as a personnel clerk, didn't use any independent discretion. Everything was up to the account manager on what to do. And they're basically, I don't want to say glorified secretary, but they really were an assistant to the account manager in that respect. So they didn't qualify for the administrative exemption. So it's really fact sensitive. You have to look through your job description and actually see what these people are actually doing. It comes up in due diligence all the time. Marty will tell you. People think a lot of people do think just because they pay them a certain amount, they're automatically qualify. Again, they have to also meet the duties test.
Chris, I get this question all the time from clients with respect to this, and that is less better or more better? And what do I mean by that? Is it better for, they want to know, is it better for them to really take their time and detail out job descriptions and really try to, be very careful and concise in how they describe people's job duties, or is less more, right? To have less in writing, because if you say one word or you put one word in the wrong place in your description, could be held against you and have less, and therefore have more ability to have what's actually being done more significant in an audit. What's your advice? Is your advice to do less or do more in terms of describing roles and duties?
I think personally, I put more in, because that's the first look that the auditor is taking, right? They're looking at the job description. They're not looking at what the person actually does. Different. I'm not saying that you should create a job description and have the job be something totally different, but if you can at least pass that smell test with the auditor by showing them the job description, the auditor just may move on and say, okay, yeah, I can see from this, it meets the exemption. Let's not waste any more time on this.
Thanks, Chris. Another one that I know a lot of our clients ask us about is outside sales and classification for outside sales. Can you talk a little bit about the mistakes that some clients make there?
Yeah, the issue typically lies in how often the individuals outside the workplace at client sites or meeting with clients. There's no hard and fast percentage that the regulations put out, but we typically like to see it at least 50%. If it's less, depending on how much and the substance of what they're doing while they're out, we can typically make arguments to support the exemption. What the FLSA says is an outside sales employee is an employee who makes sales at the customer's place of business. Does not include sales by mail, telephone, internet, unless that's part of the whole sales process. So any fixed site, whether it's home or at the office used by a salesperson, is not going to be considered outside salesperson. That's going to be considered an inside salesperson who is not eligible for that exemption. Maybe they qualify under the administrative exemption, but they're not qualifying under the outside salesperson exemption.
Thanks, Chris. And then it's pretty straightforward, but I think some people still get confused by the computer professional exemption. Can you walk us through that exemption, when it applies and when it doesn't apply?
Yep. So you have to meet one of the 4 definitions of a computer professional, and I'm not going to read all 4. They're basically, you have to be a learned professional applying, analyzing computer programs, right? It can't just be data processor. You also have to be paid at least $27.63 per hour to be exempt from overtime. But you want to keep in mind, much like what Jerry said about the market approach, is if a state law provides for a better benefit than the FLSA does, that state law is going to apply. So for instance, in Pennsylvania, there's no exemption for computer professionals, right? Meaning they're entitled to overtime pay. So when you're hiring someone from Pennsylvania, make sure you know you're paying them $100 an hour. You don't expect to pay them $150 an hour. If you have to have something in place where they cannot work more than 40 hours per week. There's also right now, Minnesota, Nevada, New Mexico, Nebraska, Michigan, and Maine have similar non-exemptions for computer professionals. North Dakota and California also differ a little bit slightly. With California, the pay rate is a lot higher. Right now, it currently sits at $47.48.
And Chris, I think that's an important point to point out, because I am starting to see a lot of clients of the staffing firms just having these people work more than 40 hours and saying, yeah, we'll take care of it. And then when you go back to collect the overtime pay, they're not paying the overtime pay. They're sticking it on to the staffing firm. Yep. So I think that's a great point that you guys just brought up, because it is something I'm seeing a lot of lately.
Yeah, you got to build in those margins. And if you haven't built those margins in with the client,
yep,
that margin doesn't look so great afterwards.
Thanks, Chris. Well, we're getting close to the end of the time here, Jerry. I don't know if there's any other common mistakes that you want to share. You have one more you want to share?
Yeah, I mean, I do think that, you know, one of the things we see a lot of in the IT world is, and I'm sure you guys run into this, is that independent contractor issue, you know, where, you know, an individual puts themselves out, you know, ready to work, sets up a single member LLC, and everybody thinks that's fine and dandy. And part of the problem is we're starting to see a lot of states, specifically the unemployment areas, going after that and claiming that those are not true independent contractors as it relates to unemployment tax. So what we're finding is, and again, this is more legal, so I bring this up for discussion here, is we're finding that what we're seeing is that the workers' compensation, if that company or employee that subcontracted is paying for their own workers' compensation, it's giving us a little bit more of that window dressing and, you know, kind of crossing some more T's and dotting I's. And we're starting to get out of some of these unemployment audits. However, we've run into a couple states where they are just not backing down, and they're claiming because of, you know, performance, you're dictating, you're doing this, you're doing that, you know, they're not independent contractors. So I think that that's another area, and I know you guys have done some work on that, but I do believe that's something that, you know, from a compliance standpoint, we need to make sure that, you know, these firms are really taking a hard look at that.
Yeah, I think the problem with that too, Jerry, is a lot of these single member entities, state laws don't require you to have workers' comp insurance for those single member entities. So they're not getting it because it's simply not required. It really, again, this is going to be a state by state issue that you have to look at and see how the contract's written.
Yeah,
I mean, I know it's a small dollar amount, Marty, but you're talking anywhere from $56 to $200 per independent contractor. But if you got a couple hundred independent contractors, now all of a sudden it becomes a costly adventure for you.
well, I think for me, there's two aspects to this, right? Because there's always a test that has to be applied on who's controlling the work and things of that nature. And that's going to be circumstance by circumstance. But often the case with these audits, it's what I call the first impression test, because auditors like to find paths of least resistance, right? That they tend to like easy cases over more difficult cases. That's not necessarily the case with every auditor, but can be said a lot that they like an easy case. So
Right.
what that means is, you want to have everything buttoned up so that it looks very much like this person is an independent contractor, before you get into some of the gray area tests and insurance across the board. So it's not just workers' comp insurance. They should have their own E&O insurance, right?
Right.
They should have all of their own insurances. And a lot of our larger clients are setting up programs. So it's not that hard to do. They're setting up programs where their independent contractors and their contractors can come forward, can step into the program and can purchase all of the insurances they need for their LLC or whatever entity they have. But there's a whole, and Chris is on top of this, there's a whole checklist of items that you want to have that present this individual as an independent contractor. And that's really important. Some of our clients don't look to see if the entity was ever formed, if the entity is still in good standing. I have an M&A deal now where IT staffing firm is acquiring another IT staffing firm, and our client has very robust checklist on what needs to happen here, and the firm they're acquiring much less robust. So now we're into a whole debate over how are we going to handle the reps and warranties? How are we going to handle the indemnification issues? How are we going to handle transfer of these folks from one system to the other, and attempting to get some of the missing details that were in the seller's checklist. So to me, you can control this checklist. You can control the initial first impression. Staffing firms need to do a better job of having a good first impression. It's not a guarantee that when they look at the rest of the test, they're going to pass, but it goes a long way to putting them in the right direction.
Absolutely.
Well, that is their time, or a lot of time. Jerry, as always, really appreciate you coming on and sharing your wisdom and knowledge with folks.
Appreciate it, Marty and Chris and TechServe. Really, really appreciate it. Can't wait to see everybody in a couple of weeks, actually. Looking forward to TechServe.
And Sydney, thank you so much for allowing us this opportunity, and I'll turn it over to you.
Thank you so much, Marty, Chris, and Jerry, and thank you all for joining. We ask that you please fill out the survey upon exiting this webinar. Please send any further questions to staff@techservealliance.org. Thanks, and have a great day.